Hey folks, this is Ignacio with North Star Senior Advisors. Thank you for joining us this morning. Today, we're going to be discussing probate. Really quick about us, North Star Senior Advisors. We're a senior placement company. We've been here in Central Florida about 6 years. We help seniors and families transition into assisted living and memory care options. Also, feel free to check out our website for videos like these and our YouTube channel. So again, this morning, probate is the topic, and I have the pleasure of joining me, Kathleen Flamnmia with Flammia Elder Law Firm. She'll be discussing the topic for us in detail. So Kathleen, good morning. You mind introducing yourself?
Good morning. Good morning. I'm Kathleen Flamnmia. I am the owner, president of the Flammia Elder Law Firm. I've been practicing law for 31 years. I'm Florida Bar Board certified in elder law, and I'm also accredited by the Veterans Administration to represent veterans before the VA. Good morning, Igancio, and I'm very happy to be here with you today.
Thank you, Kathleen. I'm glad you took the time. I think this is a great topic. I'll be honest, personally, I've heard it. I think I have a general understanding, so I know folks that are watching this and are not within the industry can definitely benefit from this information. So let's dive right in. What is probate? If you can define it for us in detail, do you mind doing that for us?
Not at all. So probate, a lot of the public thinks probate is the dreaded word that they don't want to hear, and they don't want to have any of their assets go through when they die. But it's basically the process of, after someone passes, transferring the assets that were in their name and their name alone to someone else. And in order to get them out of the decedent's name to someone else's name, it goes through the process called probate.
Got it. Okay. So how exactly does that work? How do you get that coordinated? Is that something that a loved one can do for you, or is that something that happens automatically?
No, it certainly doesn't happen automatically. What happens is, if you have a will, you bring it to the lawyer who's going to handle the probate, and it's recorded in the county where you passed along with your death certificate. If you don't have a will, then the Florida statute says who's going to be inheriting from you. Whether you have a will or not, your personal representative will be issued letters of administration from the probate judge. And that's the instrument that gives your personal representative the ability to act on the decedent's behalf. So they could go to the bank and close out the bank accounts in order to put them into an estate account. They would have the authority, if the will has the ability to sell, gives the personal representative the ability to sell real estate. If there is no will, the personal representative needs to seek a court order in order to sell. But the important point to note is that once the letters of administration are issued, the lawyer publishes the notice to creditors, and that tells the whole world that the decedent died. And a creditor, meaning someone that the decedent owed money to, has 3 months to file a valid, timely claim. They file a claim, meaning the decedent owed them money before the person died, then they just have those 90 days after that notice to creditors is published to file a claim. And the lawyer sends what we call actual notice to people that the decedent owed money to. But that 90-day window cuts off the time frame for a creditor to file a claim. So once that's done, and once the creditors are paid, then whomever the decedent wanted to inherit in their will, or without a will, whoever the Florida law says inherit, will actually inherit the money that goes through the estate.
Okay, got it. So having a will is important in this process, right? So that way, I would think your wishes are kind of adhered to. If I'm understanding you correctly, if there's no will, the state or the judge will make that decision based on maybe next of kin, or is that correct?
The Florida statute says who will inherit from you. So it's basically your family, think of it that way, your bloodline, except for your spouse, of course. They will inherit as well. But it's the Florida statute that's going to tell the personal representative who will inherit from you if you die without a will.
Okay. And how quick does this happen? You mentioned there's a 90-day window. So let's say, unfortunately, somebody passes. Let's say, worst case scenario, there's no will, and the state has to kind of step in and make this decision. How long within that 90-day process does the 90-day clock start the moment the judge makes the decision and gives out the notices, or is it the moment the individual passes?
So the 90-day, well, first of all, what gets everything started is the judge issuing the letters of administration, the personal representative. Once those are issued, we can publish the notice to creditors, and that 90-day window starts. But that's not going to happen without a personal representative stepping up and getting the ball rolling through the probate court. For those estates that are under the federal exclusion amount, which right now is 11.58 million, most estates are closed within 9 to 12 months of being opened.
Got it. Okay. Now, is there a possibility for debt to be passed on? So it's not always going to be the scenario, I would think, where there's an inheritance. There could potentially be some debt, medical bills. Is that also the case?
The only debt that gets paid out of the estate are from the creditors that file a claim. The family members were not responsible for the decedent, the person who died, debt, unless they signed to be individually liable for it. So, for example, if a husband and wife were joined on a credit card and the husband died, the wife is still responsible for paying that credit card. It's not even something that we're going to notice the husband's creditors of, because the wife is alive and is legally, financially responsible for paying that credit card.
Okay, makes sense. So is probate something that has to happen, or is that something you could potentially avoid altogether?
You can avoid it altogether by utilizing a trust, either revocable or irrevocable trust. But also, I often tell clients that if you have a married couple, on the death of the first spouse, there typically is not a probate. And that is because most assets between a married couple are either jointly titled, for instance, a bank account or the real estate, the homestead. It's titled as husband and wife. And so therefore, when one part of that couple dies, the other part of the couple is still an owner. If the decedent died leaving an asset just in their name, like an IRA or 401k, and if they listed someone as a beneficiary, that asset's going to avoid probate as well. So to recap, if you have a jointly titled asset, it will avoid probate because the surviving owner owns it. Or if you've listed a beneficiary on an asset that was individually owned, it will also avoid probate and go directly to that named beneficiary.
Okay, got it. And do you mind touching for us the difference between the trusts? I know that could be a topic all on itself potentially, but maybe high level, the difference between the two trusts, maybe quick pros and cons.
So oftentimes people want a revocable trust, which is one that by its name can be revoked, modified, terminated, or amended, meaning you can make changes to it. It does not provide any creditor protection. And as an elder law attorney, we do a lot of Medicaid planning and VA planning for people that don't have long-term care insurance and they want help paying for the assisted living or the nursing home. So we often use, instead of a revocable trust, an irrevocable trust, which is one that we create, and once assets are transferred into it, you've got to pass a certain period of time before you're eligible for benefits. For VA, there's a 3-year look back, and for Medicaid, a 5-year look back. But once we make it through that look back period, then the assets in that trust are not counted as an available resource. And additionally, the assets in that trust do not go through probate.
Excellent. Well, this is awesome information, very helpful for me, and I hope the folks watching, I hope you found this information useful as well. We're going to have here, folks, on the bottom, our contact information, Kathleen's information as well. Kathleen, do you mind sharing with us maybe your website and office number really quick as well?
Of course. My website is flammialaw.com, which is spelled F as in Frank, L-A, M as in Mary, I-A, L-A-W.com. My phone number is area code 478-8700.
Got it. All right, so thank you again, Kathleen, for taking the time. This is a great topic, folks. Feel free to visit Kathleen's website. She's got a wealth of information on there as well. And thank you for joining us today. And if you have any questions, give us a call. Stay safe. Thank you, Kathleen.
Thank you.
All right, bye-bye.